Welcome viewers. I'm Ashish Singh and we are back with another edition of the Geo interview with Professor Paula Gaeta. She is the Professor of International Law at Graduate Institute, Geneva, and is currently the member of the editorial board of the Journal of International Criminal Justice. Professor Gaeta's recent publications include the 1949 Geneva Conventions, a commentary, the Oxford Handbook of International Law in Armed Conflict, the third edition of Cases, International Criminal Law, the UN Genocide Convention, a commentary, and the Statute of the International Criminal Court, a commentary. Professor, we would like to welcome you to the Geostrata.
Thank you, and thank you for inviting me. It's a pleasure to be here with you today. Thank you.
Thank you so much. So this interview will be on international criminal law and global conflict. So we can start with the first question. So Professor Gaeta, could you please define what is international law in technical parlance, and which international governance structures uphold international law?
Wow, this is a big question. This is a super big question. I mean, generally speaking, international law is the law that governs the relationship among states. But this is a very old-fashioned definition of international law, because international law now does much more than that. Of course, not only it regulates the behavior of states in their international dealings, it also has expanded the range of the so-called international actors that come under the purview of the regulation of international law. I may mention international organizations, non-state armed groups. There is a debate about whether or not the business companies also behaviors are regulated by international law, and so on and so forth. In addition to that, international law, of course, now deals not only with aspects related to the coexistence of states and different actors, but also cooperation among these different actors. So essentially, there are a variety of institutions that are relevant for the governance of international law at various levels, international and global level, and regional level as well. I think that the most important organization I should mention is the United Nations, as we know, because of its universal scope and mandate. Clearly, it is the most important organization that we shall refer to when we speak of international law and its governance.
Perfect. Now that we have that framework to begin with, I would like to ask you, how do you locate criminality in international law? How does international law view criminality?
And this is interesting, Ashish, because of course, since I said that international law is the body of law that primarily regulates the behavior among states, clearly, first of all, we shall say that states cannot commit crimes in the traditional sense. So whenever we speak of the relevance of international law vis-à-vis criminality, we are discussing a particular kind of criminality which is committed against international law, against international law rules that are considered to be important for the international community as a whole. So not every aspect of individual criminality would come into place. So a murder would be murder for domestic law, but it's not something that is of interest to international law unless such a murder, for instance, is committed in a particular context. For instance, is committing during an armed conflict against a protected person. In this case, the murder would also qualify as a war crime because of the particular context the murder has taken place. Similarly, if killings takes place in a systematic or widespread manner against a civilian population, this act of criminality would be upgraded to a crime against humanity, and therefore this would be of international concern to the international community as a whole. So the international law deals with criminality in an exceptional manner when certain crimes have been committed in a particular context as to trigger the interest of international community as a whole.
That's very informative to hear. Thanks, Professor. And now that we have a background on how does international criminality work in terms of international law, I think that opens up a gateway to understanding, the position of international institutions and international law and institutions such as the ICJ on the Russia-Ukraine crisis. So could you please share with us how is international law shaping up and looking at this crisis?
Yes, the example that you provide is quite important because, as I said at the beginning, international law deals with the behavior primarily of states and other international actors, and then it also look at the individuals' behaviors when they commit to certain violations of international law that amount to international crimes. So in the context of the current Russian-Ukrainian war, there are two levels that we have to look at. First of all, there is the behavior of states, and they are behaviors that may be in contradiction, in violation of international law. So it is evident that to many that Russia is responsible for a serious violation of international law vis-à-vis Ukraine, since it has conducted an act of armed aggression against Ukraine. And in addition to that, during the war, a variety of violations of international law of armed conflict and human rights are committed during such a conflict. And this entails state responsibility at the international level. And the International Court of Justice that you mentioned is the principal judicial body of the United Nations, and it deals only with dispute settlement between states. So there is currently a case which is pending before the International Court of Justice, which has been brought by Ukraine against Russia. For Ukraine's side, that Russia has manipulated the definition of genocide to justify its armed aggression against Ukraine. So there is currently a case pending before the International Court of Justice on this specific matter. Differently, of course, the criminality acts of criminality that may be committed during the conflict come under the jurisdiction of international courts and tribunals, in particular the International Criminal Court, whose jurisdiction has been accepted ad hoc by Ukraine. So currently there are investigations by the prosecutor of the International Criminal Court concerning the acts of criminality committed by individuals. And everybody knows that a few weeks ago, the prosecutor of the International Criminal Court has requested and obtained by the pretrial chamber of the International Criminal Court an arrest warrant, to issue an arrest warrant against President Putin and other leaders for certain crimes committed during the Ukrainian conflict.
Interesting. Now that we have that information about the various proceedings that are happening around the Russia-Ukraine crisis in international law, we can now introduce more elements to it, let's say human rights law and humanitarian law. So could you please explain, can international law and enforcement structures that you talked about act to stop ongoing civilian hostilities and situations such as Sudan, precipitated by the warring military and paramilitary factions?
Well, usually let me say that, the existence of a law does not prevent the commission or does not stop the crimes. So the fact that in every domestic legal system you have criminal law, this does not stop crimes that may be committed by individuals, but certainly it is a standard that it is adopted, legal mandatory standard against which one can adjudicate criminal responsibility. So this is the same for international criminal law at the international level. Per se, international criminal law cannot stop offenses, although clearly the existence of such a standard at the international level should also serve as general deterrence for future criminality and specific deterrence in some circumstances. But it is a wishful thinking to think that the existence of a body of law can stop any criminality. When it comes to the enforcement aspect, this is something very important because international law, again, I repeat, is the law regulating primarily the behavior among states. And states are characterized by their sovereignty. Sovereignty means that they detain the monopoly of legitimate violence within a particular territory, and they do not recognize any superior authority. So having said so, as you might imagine, it's quite difficult for international law institutions to coerce a particular state to put in place mechanism to enforce international criminal law in particular. This is left in a way to the states themselves. These states have the obligations under international law to prosecute international crimes, to prevent violations of international humanitarian law, and so on and so forth. But besides setting such an obligation, international law cannot really interfere, cannot really intrude into the sovereignty of states. Of course, there are a variety of mechanisms that may be relevant to try to induce states to do so through sanctions, through military intervention from outside, and other mechanisms that may think of. But in essence, you cannot really impose from outside to a sovereign state the compliance with international humanitarian law or international human rights law, and so on and so forth. And this is true also for the International Criminal Court, because the International Criminal Court is a court which does not have a police that can be sent to a state to arrest alleged criminals or to stop violations that are occurring. That's not possible for the International Criminal Court. The International Criminal Court can only rely upon the judicial cooperation of the relevant state or other states as well. So you see, this is quite difficult, because you have to, from one side, you have values that have been enshrined in agreed international rules, including by the relevant state, which is perhaps violating those rules. At the other side, you have the fact that international society is organized based on the principle of state sovereignty, and therefore the way to interfere are limited.
That's a very important observation in terms of state sovereignty and then international law. There is a bit of paradox when we try to reconcile these concepts, and I think that is the very essence of this interview. So from one ambiguity, we jump to the next. So could you please tell us about your project, Laws and War Crimes? And in that context, could you also please talk about the risk of responsibility gap in terms of ambiguous criminal intent in context of autonomous or mixed weapon systems in war crimes?
Oh, again, it's a big question. Yes, my project, which has just been completed, however, it was on lethal autonomous weapons. Namely, this is a category of new weaponry that states are developing by ingraining artificial intelligence within weapon systems, so that those weapon systems may, in the end, decide to select and hit a human target without control from a human being. So that's the scope of this weaponry that I've studied. So these lethal autonomous weapons, there are already some weapon systems that have a high degree of autonomy, but so far, to the best of our knowledge, these autonomous weapon systems are not autonomous to select and hit a human target. So the question that has been raised from various fronts is to say, well, these weapons, first of all, might have raise ethical concerns, because you cannot leave to a machine the ultimate decision to take a human life. But also, from the legal point of view, there is an aspect of responsibility gap, which is not specific to lethal autonomous weapons, but is specific to any kind of autonomous entity. You may think of autonomous cars that are currently being developed that can drive autonomously from a human being in the cities, in the streets. So what happens if these entities, these autonomous vehicles, while they function, they end up committing a violation of international law, who is responsible for such a violation? So you might think of an autonomous weapon system that has been developed, I don't know, to target enemy military combatants, so members of the enemy armed forces, which is something not prohibited by international law, but instead of hitting the enemy military combatant, they end up hitting a school where children attending classes. So this would be a violation of international law. Is there anyone responsible for this violation of international law and eventually criminally responsible for a war crime, because killing children at school in an armed conflict in a deliberate manner is a war crime? So my project has dealt with this particular issue. And I don't want to be too technical, but there is a variety of problems. There are a variety of problems here which pertain to the possibility for human beings to retain control over the weapon at the different stages. So from the different levels, from the point of view of the programmers, developers, and the user. So the question is about the possibility for humans to be in control, and the question of whether or not there is a link between the decision by a human being to employ this weapon system and the fact that this weapon system may malfunction. Can you really attribute blame to the human being who has used the technology in a way which was not intended to hit the children at school, but in a way which was not unlawful initially, but ended up to cause harm to innocent civilians? So this was the scope of my research project.
Thank you for sharing that, Professor. And just to go back to a previous point that we left about the paradox of domestic sovereignty and then the enforcement of international law on states. There is this dichotomy, and how to reconcile this, how to enforce international law in conditions where, let's say, offending states say, okay, it's our internal matter. How to enforce international law in such circumstances? What are the resources or international institutions to draw upon? Could you please sort of clarify this and that problem to students and young people interested in international relations?
Yes, this is a fundamental question indeed, and there is a long-standing debate about whether or not international law is law in the first place, exactly because, let's say, the mechanisms to enforce international law may be seen not as effective as the ones that exist in domestic settings. So there is a big debate which dates back, centuries ago. But in essence, this brings us what is law for us, first of all, or if it is something that necessarily must be accompanied by a sanction, by an enforcement mechanism or not. So in general, of course, international law, being the law primarily among sovereign states, would require some sort of self-compliance. So states agreeing, because the states are also the legislators, so states are also those who create international law. So in principle, since they create a law, in principle, you can assume that they would like to comply with the law. They have some interest in creating such a law, and therefore they will be complying with the law itself. And indeed, international law very much rely upon self-compliance. And in the majority of cases, we don't see it. International law is complied by states. There are certain instances, of course, of transgressions with international law, which is created by states, as I said, themselves. And those instances are those where clearly there are major geopolitical interests, which could be in a variety of fields, including, but not necessarily only in the law, in the use of force, in the use of military force. Now, in those instances, in particular, when international law is violated by powerful states, the possibility to enforce international law are difficult because the traditional mechanism to enforce international law is for the victim state, so the state which has suffered a violation of international law, to use what we call sanctions or coercive measures vis-a-vis the state who is responsible for its violation. But as you might imagine, if the violator of international law is a powerful state, the possibility for the victim state, if it is not a powerful state, to react are minimal. So in this respect, clearly there exists a variety of mechanisms and a variety of institutions that have developed over time, so not only the United Nations, but also mechanism for the settlement of disputes. So we mentioned the International Court of Justice, but there are others at the regional level. There is diplomacy. That is, of course, a very important mechanism to induce compliance. And all those mechanisms, they try to put some sort of moral suasion or to induce compliance. That's it. Clearly, this may be seen as a contradiction, but I don't think it's a contradiction. I think it's the fact that international law, being the law of sovereign states, cannot be other than that. Because if there would be the possibility to induce compliance from above in a coercive manner, as it is the case for domestic legal systems where we have a sovereign above us, sending us the police and imposing on us the settlement of disputes before judges, then the international law society would be something else. Would be similar to state structure, and it is not. It's an anarchical society. And the fact that international law exists and has developed over centuries to guarantee, first of all, the coexistence between states and then the cooperation between states is a sign of progress. And I think that we shall continue such a progress by strengthening international law institutions.
Very important clarification there for students. Thank you so much. And to go forward, and you talked that the international system is anarchic. Me being a student of IR from the Global South, from India, I would like to share something with you about the debate that goes on perceptions of the international system. People in Global South tend to think that international system is hierarchical and not anarchic. So when it's hierarchical, there's a group of states, there's a group of satisfied middle big powers for making these international law, international structures, and then imposing it on the Global South, on developing countries who think that they do not have agency in the making and enforcement of such dictates. For example, the UNSC, Security Council structure of veto, etc., which is, of course, not as democratic as we would like it to be. So this is a Global South perspective from a student to you. How would you engage with that, and what is your position on that? Like, anarchic versus hierarchical, and where does international law fit from the perspective of Global South in this entire discourse?
Yes, that's an important question, of course. So when I said that international law society is by definition anarchical, I meant that there is no centralized structure that can really impose the will or the international law rules upon a sovereign state. There are a variety of examples where we can see this, including the impossibility to impose such a will to countries of the Global South. As you mentioned, the conflict in Sudan. This is one of the examples. I mean, how can you impose on Sudan the compliance with certain rules from above, even though you might have the Security Council and all the rest? I mean, still, in the end, it's important to notice that every state is a sovereign state, and there is a lack of centralized structure that, in the end, have the ultimate word to say. Having said so, what you say, however, of the perspective of the Global South is perfectly clear. It is true that, first of all, there may be a hierarchy in terms of the normative values that are protected and the way they are protected. And also international law has been seen as the product of Western tradition. But that's because international law exists since centuries. And as we know very well, until few decades ago, I mean, the international society was composed of Christian states for the majority. And it was only through the process of decolonization between the 50s and the 60s and the 70s that international society has become something else. This may be seen as past history, but it's very recent history when it comes to the history of international law. And therefore, the process of decolonization and the emergence of new powers, including from the global south, are necessarily challenging the traditional structure and institutions of international law that developed since the Peace of Westphalia 1648. So as you might imagine, I think that we are in the process of transformation of international law, its institutions, and I think that the global south is now pushing to make its voice to be heard. And we will see what will happen in the development of international law for the future generations.
Of course, we will see what happens from the global south perspective. And thank you so much for giving us that perspective about how the global south sees international law and then the nuances of it. And of course, the history of evolution of international society as a whole, which we often tend to ignore or put under the brush in debates about international law. We only talk about the present while there's an entire past of evolution. And when we take that into account, there is a democratic element in that which needs to be factored in. And just to move towards the conclusion of this interview, as an academic in international law, Professor, how do you feel about your own contributions to the field? I mean, you have generated a huge corpus of research and literature. How do you feel about your own contributions to international law? And how do you see the significance of your practice as an international law expert in the evolution of international law in the future with these emerging technologies, etc.?
You may be surprised by my answer. I think that my best role as an academic is to teach my students. I don't think that my major contribution could be seen in my scholarship. I don't see, yes, I've tried to do my best to be critical vis-a-vis current institutions of international law. I'm very critical vis-a-vis the Security Council and other institutions of international law, the way technology is used in armed conflict. But I don't think that the best contribution I can give is in that respect. On the contrary, I very much believe in the current and future generations who can take an important role to try to better our current society, international society. And I have the privilege to teach at the Geneva Graduate Institute, where I have a cohort of international students every year, including from India and including from any other coin of the globe. And what I try to do is to try to do my best to help them to become the citizens of the world of the future and to have a better world.
Thank you so much, Professor. That's really inspiring to know about how does not only an expert but also an academic think about the onus of transferring information to the next generation about issues that matter to the world, issues that have shaped international debates, international world, everything. So thank you so much for your time, Professor. And lastly, do you have any last message for young people interested in international relations or international law who are planning their masters from that perspective?
Yeah, I mean, the message is, I think, it's the following. Of course, if we look around us, we are very depressed by seeing all the problems that we're facing, climate change, wars, famine, and I mean, the list is so long that it becomes depressing to think about it. But I think that indeed, we shall not be afraid to try to do our best. And because each of us in our individual little lives, we can make a little difference for all the kind of, I mean, there is no particular recipe or magic solution that I have in my pocket, but certainly I think that everybody with humbleness and honesty could do the difference. So I encourage everyone to think, not to become cynical, because this is the risk, to become cynical and to think that these institutions do not serve any purpose, international law doesn't serve any purpose. No, I don't think that's true. If we look behind us, we see how much international law society has progressed thanks to the goodwill and humbleness of so many people. And I think we should do our best to be one of them.
That's a perfect note to end this interview on, Professor. And the entire Geostrata extends their heartfelt thanks to you in this tremendous effort of clarifying international law to young stakeholders across the world, across Global South, across youth constituencies that we cater to. And we ensure you that we would love to scale up this effort and take forward your voice and your explanations to young people across the world. Thank you so much again for engaging with us, and we look forward to keeping connected with you in the future.
Thank you so much for having me. Thank you.